Right. Good evening, everyone, and welcome to continuation of our revision towards 2022 Ghana School of Law Entrance Examination. I accept my apology for my inability to have met you yesterday, contrary to what I would have wished to happen. I think some of you were able to explain my situation to the others. But because we couldn't do yesterday's lesson, even though I'm geographically not at a good place where I would have loved to do the class, but I don't want to be skipping at least the 1 or 1.5 hours engagement every night, I promise. So just let us manage. As you can notice, the lighting is not the best, but at least you can hear me. So tonight we would like to have one focused lesson on how to solve a problem-based question in contracts. Next time we take an area in torts, and another time we take an area probably in land law. My discussion of a problem question that I have selected is going to be informed by observations made by examiners and, of course, myself as a teacher of contract for some time. So just before we go into what I would like us to do tonight, that is the discussion of the selected problem-based question. It is important that we remind ourselves that when it comes to problem-based question, we need to be clear in our approach. And when I say be clear in our approach, we as students of the law in the common law world, and in fact, all over the world where law is taught and learned, are very familiar with the structured approach. Please mute yourself, mute yourself. Mute yourself. Okay, let me mute everybody then. Yeah, so what is that anytime we have a problem, we must ask ourselves what area of the law, what areas of the law does the problem that we have been presented with actually provoke or implicated? We need to ask ourselves, because that is important. Knowing if I say the area of the law, and especially for purposes of law school entrance examination, the area of the law will also encapsulate, if you like, the particular subject area. Particularly so when the type of exams that you are doing, it is a composite paper in the sense that they have not actually stated that you are doing constitutional law paper, or you are doing criminal law, or you are doing tort, or you are doing land law, Ghana legal system and legal method, and so on and so forth. We are just giving one paper. And for essay questions, it will often be straightforward for you to know which particular area the examiner is trying to test your knowledge. But for scenario or hypothetical set of facts or problem-based question, sometimes it may not be that straightforward. And if you talk to examiners and markers of this examination, sometimes the impression you get is that students either deviate, especially so where maybe the examiner is thinking of a problem in contract. The student may also be thinking of maybe a general problem in, let's say either tort, or even some even go to criminal law, or when we used to have the commercial law, the sale of goods, So that confusion is quite rare, and we can easily fall victim into that. But the good thing is that once you decide to be structured, you decide to be logical in how you go about this. Assuming, I mean, I'm just making a general observation, assuming you are not sure whether the program that you have been given is just testing your knowledge only in law of contract. And if you look at the set of facts, and for example, maybe an aspect of law of tort, just as an example, is implicated, or even an aspect of a land law is there. Well, so far as you've been able to identify the areas, formulate the appropriate issues, and you deal with them by telling us the relevant principles under each of them and all that, and doing the analysis by way of application and drawing the conclusions on those issues. Even if the marking scheme of the examiner was looking only at a contract, it is not likely that you are going to lose out, because if he was only thinking about contract, you have identified the issues which should be raised in contract, so you are there. Except that the time, you might have actually used a very limited time to address all the various issues which you decided to raise, which may probably not be what the examiner is thinking. And for that matter, what the examiner is thinking may probably receive a very limited attention by you. That is the only downside. But having said that, as I said, tonight, I would like us to take this question and then we think through together and then you solve it. Let me share the screen with you. Yeah, so the problem-based questions. So let's look at these adapted facts and we'll see what we can do with that. Amoako's daughter, let's say she's Boatemaa, age 21, was studying for GSL or Ghana School of Law Entrance Examination at Free Revisions Academy. It was a contractual requirement that students in residence at the academy were non-smokers. And Boatemaa, therefore, gave up smoking. Amoako, however, was worried that under the pressure of preparing for the examinations, Boatemaa will start smoking again. And so he promised to pay her 1,000 Ghana cedis if she did not smoke at all until she had completed the course. He also promised to buy her a car if she passed the examination. Amoako runs a small business and asked Boatemaa to write demand notice to debtors of the business. He was pleased with the result and said he will give her 500 Ghana cedis for all her hard work. Boatemaa passed her examination and has not started smoking again. Amoako has not made either of the promised payments or bought the car. He seeks your advice as to whether he is legally obliged to do so. Advise Amoako. Yeah, so we've been asked to advise Amoako. So now I'll take the story again so that you can digest it and internalize it before we start the discussion. Amoako's daughter, Boatemaa, age 21, was studying for GSL Entrance Examination at Free Revisions Academy. it was a contractual requirement that students in residence at the academy were non-smokers. And Boatemaa therefore gave up smoking. Amoako, however, was worried that under the pressure of preparing for the examination, Boatemaa would start smoking again. And so he promised to pay her 1,000 Ghana cedis if she did not smoke at all until she had completed the course. He also promised to buy her a car if she passed the examinations. Amoako runs a small business and asked Boatemaa to write demand notice, that is letter, to debtors of the business. He was pleased with the results and said he will give her 500 Ghana cedis for all her hard work. Boatemaa passed her examinations and has not started smoking again. Amoako has not made either of the promised payments or bought the car. He seeks your advice as to whether he is legally obliged to do the various promises, the car, the smoking and all that. So we've been asked to advise Amoako. Yeah, so as I indicated at the beginning, if you have a problem-based question, it is very helpful that having read the problem at least 2 times, and I'll say 2 times, because if you read it just at the go, you may not get the problem, very well. Let me see if the appearance will improve. Okay. Okay, so if you read the problem 2 times, you understand the story, and as you read it, it will start ringing bell in your mind in terms of the relevant areas of the law. So this one, you've already read it 2 times. I presume we remember the story. So as I indicated, in solving a problem-based question, we must have introduction to the answer. And if you look at what examiners look for in every type of question, including problem-based question, they would like introduction. And a problem-based question, introduction is supposed to address 2 main things. The first thing we should be addressed in the introduction, for example, the area of law or the areas of law. And by area of law or areas of law here, as I indicated, if it were to be in the normal school setting where you are learning particular subjects. So for example, if you are doing contract and we give you a problem-based question, well, we don't really need for you to tell us that the area of law is, let's say, offer and acceptance and the law of contract or consideration and the law of contract. We don't need that because you already know that it is a law of contract we are dealing with. But in this type of examination, where it's a composite paper, if I'm an examiner and I see a student telling me that the problem in this question raises issues and 2 subject areas, maybe law of contract and law of tort, assuming. But obviously this particular problem is quite clear and obvious, so we don't need to belabor the point. But the area of law, properly speaking, refers to the topics, right? So if you are saying that, the subject area is contra, but which topic areas? Which topic areas are relevant to the problem that we have? So that is what the introduction is supposed to do. So I'm just speaking generally about the approach, and then when I finish, I will go back to the problem and all of us will work through together. Good. So after identifying the area or areas of law, and the area of law here, as I said, the topic areas under the relevant subject, which are implicated, or which are reflected in the problem, they will have to be stated. So let us keep that in mind. Now, when you finish with that, you haven't finished with the introduction, you are still at the introduction. Now, having mapped out the areas of law in terms of like the topic areas, we would like you to identify the issues. We'd like you to generate the issues or formulate the issues. In other words, based upon the topic areas you have mapped out under the subject, which are reflected in the problem that you have read. What legal questions do you think need to be discussed, or what legal questions emanate from the story as far as the topic areas that you have already mapped out are concerned? And in doing the statement of the issues as part of the introduction, you could do it one of two ways. Either you use the first, second, third, fourth, and so on, or whether you try to use the outline approach that the issues arising from the problem are 1, 2, 3, 4, 5, and so on, or you can just number them. But the most important thing is that the introduction should do justice to the area of law or areas of law and the issues which need to be addressed. So let us keep that in mind. Now, when we are done with that, we are now coming to the real work. Each of the issues, so to speak, is a question for us to treat. So you take each issue, and I will prefer that the issue, you take the issue, if you like, you write it boldly. You write the issue boldly as a subtopic or as a heading. And then after, if you do that, it's good because it will help your examiners. Your examiners mark under pressure. So if you have that kind of thing, it will help them. Now, when you've done that, you need to proceed under that particular issue. What are the relevant rules or principles of law? And when you are stating the relevant rules or principles of law, we would like you to use what we call the topic sentence approach. State the principles of law in the form of propositions, right? And of course, the principles of law or the rules of law you are going to state, they have a source. So when you state it in the topic sentence form or in the proposition form, you need to immediately indicate the source of that. In other words, where did you come across that particular principle of law or that rule of law? Is it in a particular case? If it's in a particular case, as soon as you state the principle in the topic form or the proposition form, you need to write the case against it. Either you make a dash and then you write the case, or you can put it in a bracket, that is parenthesis, and write the case, or you make a what do you call it, the colon, and then you write the case there. Sometimes, depending upon the particular topic that you are dealing with, it may not only be a case law, you may also have a relevant legislation. So if the particular principle that you have stated, for example, emanate from a legislation, then you need to state the provision of that legislation. Maybe section 10 or section 5, section 7 of, let's say, the Contract Act 1925 or whatever, as it were. So let us keep that in mind. Now, when you have stated the principles and then the corresponding authorities, you now have to leave a paragraph and start the analysis and application. And we don't need you to write analysis of application and you underline it. Although that bad practice has going on among a good number of law students, and even, but I think that it's not quite neat. It's not really. The most important thing is that you have stated the issue that you are dealing with, and you will start stating the principles and then the authority related to them. And then you leave a paragraph and then you start the application. So when you are doing the application by way of the analysis of the relevant facts in the light of the principles that you have stated, it will be quite obvious. So the point about the application that you are going to do, you are going to apply the principles of law that you have stated, right, to the facts in order to answer the issue which you are considering, because the issue is a question. The issue needs to be answered one way or the other. And you cannot answer that until you have demonstrated that the principles that you have stated are actually satisfied by the facts of the problem that you have, or the principles that you have are not satisfied completely by the facts that you have. And for that matter, is going to influence how you answer the issue that you have formulated, the question that you have formulated. And in doing that, it may well be that there is a case law, there is a decided case, whose facts are more or less on all fours or are materially the same as the problem that you have. If that is the case, as part of your analysis and application, you may cite that case as buttressing a particular conclusion that you are trying to arrive at as far as that issue is concerned. And when you do that, you need to quickly summarize the material facts of that case. And then you tell us what the decision was in that case. And that way, you have succeeded in showing that that case you are citing supports the particular conclusion you are trying to arrive at on that particular issue that you are discussing. And here, students will ask you, sir, does it mean that when you are stating the principles and the cases, you have to tell your examiner about everything in all the cases? No, the answer is no. The first part, when you are outlining the relevant principles under the issue you are working on, you know, as I indicated, you said the principles, you must tell us the source. But doesn't mean that if the source is like a case, anytime you mention the principle and the relevant case, you're going to tell us everything about that case. No, that is not really necessary. Now, the case that you need to tell us more about is when under that issue, you are doing the application and the analysis, and you are trying to arrive at a particular conclusion on that issue. And you think that the conclusion that you have arrived at is supported by a case whose or which has got like a fact, which are really, really close to the facts that you have before you, then you can do that. Or it may well be that you have your principles, you have the facts, you've done the analysis and application, but there's a certain case which on the face of it appear to be similar to the problem that you have on hand. However, you are convinced that despite the apparent similarity between the facts of that case and the problem before you, you don't have to follow the decision, or you do not want the court to follow that decision, and you think that there is some important point of distinction between what we have in this particular problem before you and what that case was. If that is the case, you are trying to do what we call distinguishing. You are trying to say that despite the fact that the case of S and Y on the face of it appear to be similar to this, it is important to know that in that case, this particular fact here was not there. And for that matter, the courts may not have to follow the decision because of that important, if you like, distinction. So if you do it that way, you have demonstrated that, yes, you are aware that there is a decision which is very similar to the problem that you have in your question. Nevertheless, you are able to recognize maybe a very important point, a very important dimension of the facts of the current scenario before you, missing in the particular decided case, which ordinarily looks similar to the one that you have. And for that matter, you are trying to say that that should not be followed and all that. So if you go about it this way, you have done justice to one issue, and then you move on to the next issue, and you go through the same procedure. You tell us, use that issue at as a, if you like, the topic or the heading. You tell us the relevant principles or rules together with the corresponding authority that is the source of those principles and all that. And then when you are done, as I said, you leave a paragraph and then you start the application by way of analysis of the principles and the relevant facts, and then you try to draw a conclusion to answer that particular issue. So you go through that way, and then when you are done for all the issues, now you come to do the bigger conclusion, right? You come to do like the bigger conclusion. So the bigger conclusion is the conclusion to that answer. And that one, if you like, is made up of three main components. The first component of the conclusion is just bringing all the small conclusions together, because just recapping them, and then having recapped the smaller conclusions for the various issues. What is the overall conclusion? For example, you've been asked to advise someone, what is the overall conclusion? If remedies are relevant and all that, what remedy will you suggest for the particular party or the parties involved and all that? So in a nutshell, this is the approach which is recommended to be a safer approach in dealing with problem-based. I would like to take comments or questions before we work answer to the problem that I read. So if you want to speak, you can just raise up your hand, and then I will release you to talk? Or if there's anything which is not clear in terms of the approach, you can bring it up and then we discuss it together. Okay, Sandra.
Yes, please. Good evening.
Good evening, Sandra. Oh, sorry. If yeah, Sandra, you can unmute yourself.
Okay, so about the stating of the relevant laws, some people say that you don't just state the law, like let's say you want to use the case of, let's say, dairy versus pig. Instead of just putting the case there, dairy versus pig, some people say you actually have to state the case and then state the principle in the case. And also, if you're also using the constitution, like maybe Article 12 or something, you don't just state that, but you actually also state what has been written under Article 12. As in, you give an explanation of the law you're going to use. But some people also say that in the since of the relevant case laws, you don't have to explain because you explain in the analysis. So all you do is just state the law just at the relevant law section. And then when you get to analysis section, that's when you actually explain the laws. So please, which one do you
All
have?
right. Okay, Sandra, thank you. First of all, let me say that there is nothing like right or wrong, answer as far as how the IRAC is actually implemented is concerned, but is a question of simplicity. And if you look at, excuse me, if you look at how judgments are written, right? If you look at how judgments are written, and if you look at lawyers, how we write written address or submission and so on, you have an issue. You tell us about the law first before you do the application. Before you do the application. Now, in terms of you stating the principle, if you want to expound it at all, it should be extremely brief because you are not writing an essay. So that is what, if you are not writing an essay that at the statement of the law side, you are going to write a full exposition. No. You are just supposed to, what is the law? You are just supposed to state it. And then if you want to, briefly expound it for each principle, especially if you want to open it up a little bit. I don't expect you to be doing more than 2 sentences on a principle, because don't forget, you are going to do the analysis and application. So that is where you are going to do more explanation. That's where you are going to do more explanation. Well, one who have argued that if that is the case, once you get the issue, why don't you just start the analysis and application already? Since you know the principles, why not apply them direct, and then you do the necessary. Now that can be done, but as I said, there's nothing like the right or wrong in terms of the approach, but there are risks, right? If you decide to start doing the analysis and application immediately after stating the issue, the risk is that you will not have, for example, you not have demonstrated to the examiner that you have a complete understanding of the relevant law on that particular issue. And if it should also happen that even the analysis that you've done right away, let's assume that it's wrong, right? Let's assume it is wrong. And so the examiner look at his marking scheme, you are wrong, so you are going to be marked wrong for that. But assuming you've used a simple approach, and I prefer the simple approach. I like to be simple in how I respond to questions. If you had used a simple approach by, for example, after that particular issue, you tell us the law, like the principles or the rules. And as I said, you try to put them in the proposition form, right? So let's say that what do you call it? For example, let's say you are dealing with whether like this particular issue that you have concerning the promise to the daughter, Boatemaa, that if she, let's say that the letters that she did, right? She wrote a demand notice for the father to the debtors of his business. So let's suppose that we wanted to say whether the promise to pay her for that great job, which the father said was good, whether that promise, for example, is supported by a valid consideration. So you are thinking of, let's say, something like a past consideration. So you state the past consideration in the topic form that, as a general rule, a past consideration is not a good consideration. A past consideration is where the act of consideration was done or performed before a promise was made. You state the relevant authorities, Ray McAdell, and so on. Then, after the general principle, you have exception. However, then you state the exception. So the advantage of going by the simple approach is that you are going to be systematic in the statement of the law. You state the law, the general principles. If there's any exception, you state it and all that way. Before you attempt to do the analysis and application. Now, when you get to that stage, assuming, right? Assuming you were weak or not impressive in how you did the analysis and application. But let's assume that you have stated the relevant or most of the relevant principles and that issued quite accurately with the corresponding authority. In the marking scheme, we have marks for that, right? In the marking scheme, we have marks for that. And the examiner will, for example, know that, yes, you know the law probably is the way you use the law to argue, which is not good. And you will only lose some marks for that, but you get marks for you being able to state the relevant principles well. So, Sandra, that will be my comment. I don't know if that assists you. Okay, I think she's gone. Okay, so in absence of other comments or questions by students, let us look at the question itself and try and work the solution. So maybe let me bring everything together so that I can see it. I think, yeah, so we have like the full question here. I think, let me reduce it a little bit so that we can have it. Okay, so this is what I'm going to do with you. We are going to first build the introduction. So as I said, the introduction, we're supposed to identify the areas of law and then formulate the issues. So what do you think are the relevant areas of law in this particular problem? Yes, you can write it in the chat or you can raise up your hand and then I will release you for you to talk. Okay, so let me, you know something, I'm going to release all of you, but please, if you are not talking, don't unmute yourself so that we don't get the feedback here. So I'm going to release all of you. If you want to talk, you can just mute yourself. When you finish, you mute yourself again. Yeah, okay. Yeah, so the introduction, as I said, we are trying to build the areas of law and then the issues. So who will have a bite?
So please.
Yes, Mr. Anima Duantry.
Yeah, some of us didn't join early, so we don't know.
You don't know what you're doing. Oh,
yeah.
Oh, right. Okay, what we are doing tonight is that we are trying to solve a problem-based question. And I gave a general advice in terms of approach. Okay. So that is what I did. And now we have this problem that we want to try. Okay, so let's do it this way. Having read the problem, the areas of law, as I indicated, clearly, the subject area is a law of contract. There's no doubt about that. And then the topic areas, which are implicated in this problem. As you read it, you notice that the issue of consideration rings a bell. The issue of consideration rings a bell. And we saw age here. Does it matter or it does not matter? Okay, so we have the screen not being shared. The screen is not being shared. Okay, you don't see what I'm talking about. All right, sorry. Yeah, so I thought the screen was being shared, so you were following it. Sorry.
The people are raising issues about capacity. And then the Boatemaa girl, she's 821. So what about capacity?
Please, can we have one? Yeah, so, okay, so we have some people have raised issues about consideration, intention, capacity. Okay. Okay, so let me comment on them. Yes, for consideration, as you read the story, there is no doubt that consideration is relevant. Of course, we are also aware of the Contract Act position on consideration. So when it comes to statement of the law and application to, we have to be mindful of that. Because if you are a student of law of contract in Ghana and you get a problem which is also relevant to consideration, the temptation is quite great for you to be thinking as if Act 25 was not part of the laws of what? Of Ghana. And for you just be thinking along the ordinary common law principles. So we need to watch that, but we get there. Yeah, so consideration is one of the topic areas relevant to the problem. Capacity. The person who put up the capacity, apart from the age 21, is there any other thing which drove you to capacity? Can you share your thought with us? Those who put down capacity, apart from the age 21 you saw in the story, is there any other thing which actually made you go for capacity? You can mute yourself and talk if you want to talk. When you finish, let me mute yourself again. Yes. K. K. Are we interacting? Because you seem not to be responding. Okay, are you there? No, there are about 2K. So which of them put down the capacity? If you are doing questions, discussion, and you don't talk, then I will just send my lessons into just presentation, they won't discuss any question. Because if you don't talk, it's not interactive, it's not interesting, isn't it? Yeah, so those who put the capacity down, I wanted to find out whether apart from the reference to Boatemaa being 21, did you see any other thing which made you become convinced that capacity is also an area relevant to the problem? Anybody?
Hello, Doc.
Yes, George.
Yes, I think the position and the capacity to contract in Ghana is a bit different from the common law, because Ghana, according to our laws, anyone who is 18 years and above has the capacity to enter into a contract according to the 1992 Constitution and the Children's Act 1998. So I think maybe based on that, the person wanted to know if.
Okay.
Yes.
All right. Okay, all right. So that is fine. Let me see the chat. Okay, so somebody is saying that she writing the notice which fostered the father's business. But that one, does it go to capacity or it goes to intention? Or does it go to capacity or intention? Okay, so at least we have a little bit of a basis to justify why we have included capacity in the areas of law. Okay, intention to create legal relations. What in the facts? I think that somebody has already, okay, what in the facts actually supports our choice of intention to create legal relation as being one of the areas of law? Anybody? You can mute yourself, and when you finish, you mute yourself again.
Hello, Doc.
Yes.
Doc, please, there is a principle in law which states that when there is, let's say, an agreement or a statement between a child and a parent, ideally, it is not meant to create legal relations, and that it is meant to
So from the facts. So from the facts.
Yes. So
what? Yes.
From the facts, the father Amoako promising to pay her thousands to this if she doesn't smoke again, and then promising to buy her a car if she passes the examination, and then promising to give her 500 cedis for writing for her to draft the debtors notice. I think these are all meant to persuade her to for her to do what she's meant to do. So I don't think there is an intention to create any legal relation there. That is why I went for that.
All right. Okay. I mean, that's really convincing. Okay. Now let's move on to the second aspect of the introduction. And we have the areas of law. So let's formulate the issues. Yes. Will you try and then let us know the issues which may be raised? Yes. So
Doc, please, the first issue I would raise with whether or not Amoako's promise to pay Boatemaa 1,000 Ghana cedis if she did not smoke again until she had completed the course constituted a legal relation.
Constituted a legal relation.
Constituted a creation of a legal relation.
Okay. Okay, so good. But instead of putting it that way, if you are trying to raise intention to create a legal relation, I think that's where we are coming from, isn't it?
Yes, please.
All right. Okay. All right. Okay. Okay. We take it. We take it for now. So as I told you some time ago, that a very simple way to get the issues is just to start from the first sentence, go line by line. Then you ask yourself, does this really raise any issue? Okay. So Amoako's daughter, Boatemaa, age 21, was studying for GSL at Free Revisions Academy. At this stage, we are not in a position to really know whether there is any issue, isn't it? Except that the age 21 is something of interest. So we want to flag it, and later on, we come back to it. It was a contractual requirement that students in residence at the academy were non-smokers. And Boatemaa therefore gave up smoking. Is there any issue? So now you notice that because we've come across contractual requirements that students, so the 21 now will become relevant, because now you've noticed that being at the Free Revisions Academy as a student, you have a contract with the institution that you are not going to smoke. Okay, so that brings up the issue whether whether Boatemaa, being 21, had capacity to enter into contract with the academy not to smoke, so to speak. Okay, then let's move on. And Amoako therefore give up this. Sorry, Boatemaa therefore gave up the smoking. Amoako, however, was worried that under the pressure of preparing for the examination, Boatemaa will start smoking again. And so he promised to pay her 1,000 Ghana cedis if he did not smoke at all until she had completed the course. So do we have any issue from here? Is there any issue here? Is there any issue?
Yes, Doc.
What issue is that?
Whether or not Amoako's promise to pay 1,000 Ghana cedis constituted a valid contract.
Okay, whether that considered a valid contract. Okay, so that is fine, but because you have a certain area of law in mind, isn't it? So what area of law did we have in mind when we initially read the story? So that should shape how you formulate the issue. Is that not where, were you thinking about consideration here or intention?
Doc, I was thinking of intention to create legal relation.
Intention to create legal relation.
Yes.
Okay.
That is between a father and a daughter.
Okay. Okay. All right, that is fine. Or you could simply say that whether Amoako, whether the contract between Amoako and Boatemaa regarding smoking was intended to create binding legal relation, as we put it previously. Okay. It can, in terms of the formulation, we all know that various words or sentences can be used to formulate it. But what I always remind students is that when you are formulating the issue, formulate it in such a way that when you come to discuss it, you don't need to wait and think about what was I thinking when I put down this, what am I going to say? How you have catch it, how you have formulated it by itself should direct your mind to the principles that you need to canvas and how you should apply it. So, and that is why I always say that the issue formulated should be colored by the main principle in mind and also an aspect of the facts. So when you weave these two together, you'll be able to catch the issue well, and it will also assist you when you come to actually discuss the issue along the lines of IRAC that we'll be talking about. Okay, so how many issues do you have so far? How many issues do you have so far? Hello, how many issues do you have so far? Okay. Right.
Doc, we have 2 issues so far.
2 issues. Oh, okay.
Yes, please.
Okay, now let's move on. He also promised to buy her a car if she passed the examination. He also promised to buy her a car if she passed the examination. But you see, before going on, right? Before going on to that sentence, I hope you also remember that you've already raised an issue concerning the contractual capacity of Boatemaa, undertaking not to smoke in the contract with the academy. Remember that? So already, assuming that contract is valid, and Boatemaa has a contractual obligation not to smoke in the contract with the academy, and if that is the case, it also suggests another issue. The other issue it suggests is that whether Boatemaa's original obligation, right? Original obligation not to smoke, because he has obligation not to smoke in the contract with the academy. Whether that can be a good consideration to support the promise by the father to pay the 1,000 Ghana cedis if she does not smoke. So that is another related issue. That's another related issue. I don't know if you understand what I'm trying to arrive at. So what I'm doing is that first, we have noted that there's a contractual arrangement between the students of the Free Revisions Academy, including Boatemaa and the academy, not to smoke. So Boatemaa has obligation not to smoke. But we are told that the father is worried that when Boatemaa is stressed under examination practice, she may probably go back to smoking, and the father doesn't want that to happen. So the father promises her that he will pay her money if she does not actually smoke until she completes the course. So now, not smoking, or Boatemaa already has that obligation towards the academy. So regarding the promise to pay the 1,000 Ghana cedis to her for not smoking, can the Boatemaa's assurance or obligation not to smoke, can it be a good consideration to support the promise by the father to pay the 1,000? So that is another related issue. Now let's move on to the next sentence. He also promised to buy her a car if she passed the examinations. He also promised to buy her a car if she passed the examinations. Is there any issue in relation to that? Is there any issue in relation to that? I mean, the one highlighted in the green. Is there any issue? Okay, so Frank has put it whether Boatemaa presents contractual obligation not to smoke of valid consideration for Amoako's promise of 1,000 Ghana cedis. Okay, that is another good way of putting it. Okay.
Hello, doctor.
Yes.
Okay, so I think we can, with the second issue that we raised, we can raise an issue on consideration with the second one. Then come to raise the issue of intention to create a legal relation with this particular fact.
Oh, okay. So you think this particular sentence should not have any issue on its own, but it will be taken care of when we're discussing the others you've raised. Is that your point?
Not exactly. I was thinking that, you see, the second issue about she not smoking again, we try to raise an issue on whether it was intended to create legal relation.
Right.
And I'm saying that you can focus on that issue in light of consideration, whether her promise, the fact that she was owing that particular duty to the academy.
Academy, yes.
Amount to a sufficient consideration for her father's promise, so that will cater for consideration issue. Then we come to raise a intention to create legal relation issue in relation to this particular fact that you highlighted in green.
All right. Okay. So you want to raise issue as whether the promise by the father to buy the car,
yes,
was made with the intention to create legal relation.
Yes, please.
Okay. Okay.
So that we don't have intention issues, two intention issues.
Well, it does. We can have it running through, but where, let's say that we have about 2 or 3 intention issues. When it comes to the treatment, you can put them together, right? You can put them together, just list them and then you underline them. And then you state the principles on the intention to create legal relation. Then when you are doing the analysis and application, we deal with each of them one after the other, because the statement of the law is the same. It's just the application, which will vary for each of them based upon the peculiar aspect of the facts that you are dealing with. Yes. And yes, even sometimes in real life, when the lawyers are writing our addresses or submission, or even the judges, when the judges are writing judgments, especially in the appeal or even the Supreme Court, they tend to sometimes treat issues which are substantially the same. They try to treat them together because, like, the law, the law needed will be the same. It's just the analysis and application which may vary for each of them. So that can be done. So Amoako runs a small business and asks Boatemaa to write demand notice to debtors of the business. That per se does not immediately ring an issue, but maybe if you follow it up with the next sentence. He was pleased with the result and said he will give her 500 Ghana cedis for all her hard work. What issue do we get from these 2 sentences? What issue do we get from these 2 sentences? I mean, this one, let me highlight them for you. Yeah, the one in the yellow, yes.
Hello, doctor.
Yes.
I think we can raise an issue on past consideration.
Past consideration?
Yes, please.
Okay. Okay, that is fine. Can you formulate one for us?
A moment, please. Okay, so whether or not Boatemaa, whether or not Boatemaa writing a demand notice to debtors of Amoako's business amounts to a sufficient consideration for Boatema's promise to give her 500 cedis for all her hard work.
Okay. Okay. I'm just trying to flag so that when we are discussing. I'm not saying you should go and write your exams the way I'm doing it, so please. I'm just doing it just for convenience of, we don't have a bigger blackboard here, so don't go and do your exams like that, please. So let's move on. So we talk about the past consideration. Okay, Boatemaa passed the examination and has not started smoking again. Amoako. Now that sentence, does it raise any issue? Boatemaa passed the examination and has not started smoking again. Amoako has not made either of the promised payments or bought the car. Does that raise any issue? Does that raise any issue? Now he sees your advice as order is legally obliged to do so. Okay, so now, yes.
Please, under Amoako not making payments, can you say that whether or not Amoako's refusal to pay the to make the payments and buy the car constitutes a breach of contract?
Oh, okay. So you want to, okay. Okay, that is fine. Okay, so now let's make how many, those who are numbering them, how many issues you have? We have capacity somewhere here. But don't forget that the capacity issue is not just one, because it's also relevant when we're dealing with where we also have the past consideration. The capacity, I'm talking about the same, because the same Boatemaa and Boatemaa, so wherever a promise was made to Boatemaa, if we think the capacity and is important, we also have to deal with it, isn't it? Just as the intention, again, even the intention, no, there was a concern that the intention will be running through. We also need to, even where the father promised to buy, where the father promised to pay him for and pay her the 500 Ghana cedis for the hard work, is also the intention is again important, isn't it? Okay, now this is what we are going to do. let's assume that we are starting with the, I mean, we can start in any logical order. So just for what we are doing here, so let's start with the issue, all the issues related to capacity. So here, as I said, we take the issue as a heading, and then we state the principles right away. We know that capacity relates to the legal requirement to be able to engage in a transaction and so on. So every adult is presumed to be of unsound mind and for that matter has capacity. But minors or infants have limited capacity to contract. So who is a minor? We know that a minor at common law is someone who has not attained the age of 21. However, in Ghana, the age definition of a minor is fluid in the sense that various enactments have got different age. You can just give example. The Children's Act pegs it at 18. The Companies Act pegs it at 18. The Courts Act pegs it at 21. The Interpretation Act pegs it at 18. And for that matter, it is safe to conclude that if a person is 18 years, if a person is less than 18 years, that person is a minor according to any of these enactments. So let's suppose that you have stated the age aspect this way, then you go on to say that at common law, a minor can only enter into a valid contract in respect of supply of necessaries and contract of beneficial services. Cases of Nash and Iman, cases of Di Francisco and Barnum, and also the Sale of Goods Act. Remember that at 137. So you have stated the principle in an outline form like this, and then you leave a paragraph to go and do your application. So in the instant case, Boatemaa is said to be 21 years. And for that matter, the issue of Boatemaa capacity need not detain us here, because being 21, at common law, Boatemaa is considered an adult. Or at any of the relevant enactments cited, Boatemaa is considered an adult being over 18 years. And for that matter, there is no controversy regarding Boatemaa's capacity to enter into any of the contract or transactions presented in the scenario. So you notice that once you do it this way, it is no longer necessary for you to discuss the rest, because you've concluded that Boatemaa is not a minor. Boatemaa is not an infant. And if she is not a minor or an infant, then we don't need to worry ourselves as whether Boatemaa actually had capacity to enter into any of the contracts in question. So you notice that in just in a matter of a stroke, you have dismissed all the capacity aspects of the various matters that you've considered. So we finish with that. Then we take another issue. Maybe now we can take the, should we take the consideration aspect before we come to the issue relating to consideration, before we come to the intention? I think we saw one issue as whether performance of pre-contractual obligation to a third party can be a sufficient or good consideration. I think there's an issue like that in relation to the promise by Amoako to pay 1,000 Ghana cedis to Boatemaa. Should Boatemaa not smoke again? So assuming you have that issue and you are going to treat it under the IRAC, as we indicated, you have to state the relevant principles and the corresponding authority. So we say that at common law, a contract not under seal must be supported by consideration before it will be enforceable. I mean, there are a lot of cases to support that, or that you can, it's a position you can treat as right. Then you make the other point that consideration need not be adequate, but must be what? Sufficient. And that is to say that so long as something is of monetary value in the eyes of the law, that will be a good consideration, and the law or the courts will not inquire into the comparative value of what is being exchanged between the parties in order to determine whether what is being exchanged as consideration is good or not sufficient. A lot of cases to suppose that white and bluet, the case of the white and bluet, for example, is the case about the undertaking that if you ensure that the child will not cry and so on. And then the Nestle and Chapel, right? Is it the Nestle and Chapel about the chocolates? Where the chocolate wrapper, which was considered as a good consideration. And again, we also need to state that despite the fact that the court will not inquire into the comparative value of what is being exchanged in the bargain, it is not anything at all that the court will accept as what, as consideration. And for that matter, at common law, certain things may not be accepted as consideration. However, by Ghana's Contract Act, 19th Act 25, a number of important modifications have been made. For example, a performance of obligation owed to a third party will be considered as sufficient or good consideration. According to section what? What provision of the Contract Act, 19th Act 25, support the principle that where you owe obligation to third party and you perform it, that can be a sufficient consideration. Anybody? Frank?
Section 10 also. Section
10 of the Contract Act, 1960 Act 25. Okay. Okay, so you notice that we have stated the principles relation to consideration. No, of course, it's left with we come and take the past consideration and treat it separately pretty soon. So if we are doing the analysis or the application, if we take for example, the first, the contract between Boatemaa and the academy, and even the father, that if you don't smoke, then I'm going to pay you the 1,000. Giving up smoking, is it a good consideration? Is it a good consideration? Now, don't let us, is it a good consideration?
Yes.
Yes, forbearance.
Forbearance. But even then, if we take the Contract Act, we have a provision that where there is absence of consideration per se, it will not render the contract what? Invalid, isn't it? Okay, so if we are using, if you are using the forbearance, because the person has refused to do that which she could have done or which she was entitled to do, to smoke, for that matter, is something that you think should be considered as a good consideration. But can we put money value on you not smoking? Has it got money's worth? Has it got money's worth?
Of course, they are costing, you buy it, you pay.
Okay, so if you analyze it in that way, then that will make sense, because just like the case of this the Nestle in the chapel, where the court said that if we take a wrapper of chocolate, ordinarily it may seem insignificant, but it's something of value in the eye of the law. And Thomas and Thomas, the court said that every £1 was a good word consideration, or peppercorn can still be a good consideration. So at this stage, you see, when it comes, and that is why I said that it is good to attempt to state the principle and the corresponding authority before you do the analysis. Because when you get to the analysis or the application stage, that is where we will get the difference between various students in terms of how they respond to the question. In terms of the statement of the principle, all of you, a good number of students may be scoring the same marks because the same principles and then authorities, isn't it? And all of you, if you've learned properly, you'll be able to say them well. But then it is the application side where people may be more critical in their interpretation of the facts in the problem and how they apply the principle to it. And that is where there may be variation between students. Otherwise, the first part, the statement of the principles and the corresponding authorities, all of you should be getting almost like the same marks. For that matter, if you decide to skip that part and you just start application, and assuming your application alone is not very strong, what it means is that you're going to lose some of the marks. So we need to be strategic, and in examination like this, every mark counts, because one point or 1 mark can make a difference whether you pass the exams or you don't pass the exams. So if you have the opportunity to basket a lot of points or marks, let us make use of that. Okay, so what about how do you discuss the performance of obligation which is already owed to the school? Will anybody attempt to discuss that for us in the light of the principles that we've outlined? Hello. We've stated the principle, we've stated I think the section 10 of the Contract Act 1925. So will somebody attempt to do the application for us?
Sir, please, have a question.
Before we deal with that. Okay, go ahead.
With regards to the Boatemaa not smoking.
Yes.
Do we see it was a good, it was valuable in the eyes of the law as a good consideration?
Yes, I think it depends upon the arguments or the analysis which was being made. And one student argued that, well, so far as money will be used in buying it, and that you also use it, you probably get sick and all that. He was of the view that it is something which can be considered as being valuable in the eyes of the law. Yes, so that's what he said. And at this stage, you see, at this stage, we may not necessarily disagree with that line of argument, so long as he has demonstrated to us that he knows the relevant principle. And now he is trying to be creative in his interpretation of the facts vis-a-vis the relevant principle. So when you get to that stage, examiners are more liberal, so long as you are not completely off. Because if, for example, you argue that yes, smoking, you have to buy the cigarettes and you buy it, you are also going to, you take it, you're going to get sick and things like that and so on. And so it depends upon how you analyze, unless you want to say that not smoking is just something to do with maybe a certain appetite or taste that you have, and as whether we can actually frame that as something valuable, comparable to the points the court was making in the white and bluet, and then the Nestle and the Chapel type of cases. So ultimately, I would say that these conclusions or analysis are not cast in stone. The most important thing is for you to get the correct statement of the law. And also, when you start analyzing or applying it, you show that you understand the principle. And it's not the case that you don't understand it. Once you show that you understand it, but maybe your interpretation of the facts, for example, may not coincide with what another person is thinking, that is fine, in my view. Okay?
Okay. So,
right.
thank you.
Yeah, so on that note, will somebody resolve the performance of the obligation towards the third party being a sufficient consideration? Will somebody resolve that for us? Yes, any volunteer?
Hello, Sam.
Yes.
Yes, so I will want to attempt that.
Okay.
The position at common law is that the performance of a pre-existing contract or legal duty does not constitute sufficient consideration for a third party's promise or for another promise. In this case, Boatemaa is under a legal duty from the academy not to smoke. And so that does not, and so if the father comes into to promise her not to smoke and she refrains from smoking, she is already under that legal duty not to smoke. And so that will not constitute a valid consideration. However, as Section 9 of the Contract Act 1960 at 25, that position has changed. So a case to illustrate the common law position was held in a KCA versus Charmant. KCA was a high commissioner or an ambassador who was to facilitate business setting up in his home country. And then these merchants were coming and promised that if he helped them to facilitate the registration of their company quickly and so on and so forth, they will give him a share in the company. He did that, and then at the end of the day, the defendant, that's Shamat, came up that no, he has a legal duty already. So his performance or assistance to them does not constitute sufficient consideration. However, the Ghanaian position is different.
All right. Okay. So thank you for your contribution. Just a few comments and clarification I will make on your input. So first of all, at common law, even at common law, the case of Shadwell and Shadwell, right? The case of Shadwell and Shadwell support the position that where you owe obligation towards a third party in a pre-existing contract, performance of that can be a sufficient consideration to enforce another promise. Because Shadwell and Shadwell, remember, there was the gentleman was already under obligation. He had promised, just a promise to marry the fiancée at in LA Nickel. And the uncle wrote to him that he was going to support him once he actually marries. And later on, the promised payment by the uncle was not forthcoming. The matter went to court. And the court expressed the view that despite the fact that he had promised the fiancée to marry her, and if he did not marry her, of course, that could be what they call like a breach of promise to marry and so on. The court was still of the view that that was still sufficient consideration to support the promise by the uncle, that was going to support them with stipend should they get married. So the common law case of a Shadwell and Shadwell supports that. But the Kissie enchantment, right? The Kissie enchantment decided by the Ghanaian court was not really along the lines of Shadwell and Shadwell, but the court was talking about where you have, if you like, of course, a number of points, and then just one of the many points which came up as to if you have existing legal obligation as an ambassador, you're supposed to help Ghanaians who are in Liberia and all that. If you did that for a Ghanaian company in Liberia and they promise you something, can performance of your ordinary role as an ambassador be a sufficient consideration? So that one, it is along the lines of the case of Collins and Godfrey, and then what do you call the Glasgow brothers against the Glamorgan County Council, the case of Sheffield against Harris UDC, and those type of cases. But even we don't even need to go there because we know that the Contract Act has overruled or has actually jettisoned all those line of cases. And even coming back to what we're discussing, performance of the obligation towards a third party, whether that can be a good consideration. We know, I think from the Contract Act, I think either section 9 or 10, it supports the principle that if you have performed an obligation you owe to a third party, that can be a good consideration. So we need not actually worry our head about it because the Contract Act itself has stated so. And don't forget that where you are dealing with a matter and there's a statutory provision, the statutory provision definitely ranks superior to a case law. So the provision of the Contract Act is the principle which we need to stand on to resolve this particular aspect of the issue. Despite the fact that it may feel so good to be reciting all these common law cases, but unfortunately, the Contract Act has substantially modified most of these case laws. So let us keep that in mind. Okay, so now let's move on and take the other aspect of consideration before we look at intention and then we'll be winding up. I think the other aspect of consideration is the past consideration bit. And past consideration too, we know that as a general rule, consideration must proceed from the promisee to the promisor. There must be a promise first before consideration, and not vice versa, and not the other way around. And we know a lot of cases which support that a past consideration is not a good one, a good consideration. And then yes, will anybody give me authority? A past consideration is not a good consideration, the general rule. Any authority? Any authority to support that case law?
Yes, sir. McAdell's case, sir.
McAdell.
McAdell, yeah.
McAdell, okay. Okay, good. Yeah, so that is the general position at the common law. However, where the act of consideration was done in the expectation that there'll be payment, or it was done at the request of the person who has made the promise. Despite the fact that it appears to be a past consideration, it will be treated as a good or valid consideration. Remember the case of the Lampley and the Brightwit. Yeah. So these are, and this is the position at the common law. Has this provision be affected by the Contract Act in any way? Has the past consideration be affected by the Contract Act in any way? Is there any provision which is relevant or the Contract Act does not affect it? That's my question. Are we familiar at 25, please? Mr. Anyima Duanji. Okay, let me see the chat. What is inside in the chat? It's on Rescola and Thomas. But my other question, yeah, I'm Rescola and Thomas, that is fine. But my other question remains unanswered. Whether the Contract Act has affected the common law rule on past consideration. Anybody?
I don't think so.
Sorry. Did you say you think so?
I said I don't think so.
It has not been affected.
Yes.
Okay.
I have never come across any modification in the Contract Act that has modified the past consideration at common law.
Okay. Yeah, so please, the first one we said, it wasn't section 10, section 9, where you perform a duty owed to a third party, section 9, not section 10. So let's take note of that. And of as the last person also said, generally speaking, you don't have any direct provision in the Contract Act directly modifying the past consideration rule. Yes, so Lampley and Brightwit provides like the exception. So now we have the principle now. Let's do the application. So in the application, yes, Georgesian, yes. So you read section 9 and 10, section 9 and 10 together. Yeah. So let's do the application with respect to the past consideration aspect of the story. Who will try that for us? So here, all that you need to do, the person who's going to do it for us, you know the general position. If it's the general position which is appearing in the facts, and you know that is not a good consideration, so you need to find out, does the exception apply in this case? So that is all that is required of us. Yes, anybody? Are we together? Anybody?
Hello, Doug.
Yes.
Yes, I think the exception applies because the father specifically asked her to write the demand notice to the debtors of his company.
Okay.
That is, Amoako specifically requested Boatemaa to write the demand notices.
So you think that that brings it within the Lampley and Brightwit?
Exactly.
Okay. All right. Okay, so I think that should be enough for consideration. Now let's go to the last aspect, the intention to create legal relation aspect of the question. So we list the relevant issues of intention to create legal relation as our heading, and we proceed to state the principles. And intention to create legal relation, the principles are very straightforward. Will somebody do us the honor by telling us the law and the corresponding authority so that we do the application? Yes, who will volunteer for us? Any volunteer to state, to summarize the law on intention to create legal relation? Anybody? Okay, as a general rule, contracts may be either social or domestic or commercial agreement. For social and domestic agreement, the general rule or the presumption is that there is no intention to create legal relations. Case of BAFO and BAFO and all that. However, in certain situations, for example, as where married couples are no longer in a state of marriage and they are going through divorce and appropriate circumstances, intention to create legal relation may be found to be existing, as in the case of merit and what? Merit, and so on. And then in some other situations between those in the household, as in the case of is it a Simpkins and Pace? Remember that one? And so on. So you outline the principle, but of course you take a parent, like the case of Di Francisco and Barnum, that there's no intention to create legal relation between a parent and a child, or a mother and a daughter, as in that case, as we saw. So these are the general principles and exceptions as far as social and domestic agreements are concerned. And then you state the commercial agreement. Commercial agreements, the general rule or presumption is that there is intention to create legal relation. That's the general rule. You can cite the case of the Frank against the Crompton brothers, Edwards and Skyways and all that. But the exception is that where the intention of the parties clearly evident in the contract is that they do not intend to create an enforceable obligation, then despite the fact that it's ordinary a commercial agreement, it will not be visited with the presumption that there is intention to create legal relation. For example, the Crompton brothers again, where you have the honorable pledge clause or the disclaimer and so on. So that is the summary of the principles. Now let us apply them to the facts that you have. And we notice that intention to create legal relation issue run through more than one area of the story. So we, of course, I think we identify two areas, right? Where again did you find it? The intention, the promise by Amoako to buy the daughter a car if she passed the examination. Will somebody do the application for us and let us know whether there was intention or there was no intention? In relation to the promise to buy the daughter the car. Hello, are you sleeping? Are you sleeping? Yeah, please, will somebody attempt that for us? Anybody?
Hello, Doc.
Yes.
Yes, from the facts, we could tell that it's a father and daughter relationship, and based on the family or social or domestic agreement at the creation stage of the contract, both parties do not intend to create any form of legal relation to make the law to make the contract enforceable.
So what case illustrates that? What case support that conclusion? There's a case
Okay,
which is very similar.
there is Petit versus Petit.
What happened in Petit and Petit?
It was a father and son agreement, which at the time of at the creation stage of the contract, both parties did not intend to create legal relation. Hence, the contract was not meant to be enforceable.
Okay. What about Di Francisco and Banu?
Unfortunately, I've not read that, but I know of
No, I didn't know. No,
Achampong.
Sorry, Jones and Padaverton. No, Jones and Padaverton. Not Di Francisco and what happened in Jones and Padaverton? I think the mother and the daughter. Remember that case?
Yeah.
The mother and the daughter, where the daughter was working in an embassy, and then the mother encouraged her to go to London and learn to become a barrister. And the mother said that she had a property which she could let the daughter live in that property. And later on, there was a development, and the mother decided to eject the daughter from the property and also cease giving the rent to her. And the daughter sought to enforce the promise by the mother. And the court said that there was no intention to create legal relation at the time that the promise was made. It was a normal mother-daughter relationship. So the case is Jones and Padaverton, not Di Francisco and Barnum place. It's rather Jones and Padaverton. Di Francisco and Barnum relates to a contract for beneficial service, which contains onerous clauses. But here we are talking about Jones and Padaverton. Okay, so I think for the first part, it's very easy for you to conclude that there was no intention to create legal relation. But let's look at the other aspects. The promise by the father to pay her 500 Ghana cedis for all her hard work. Should we say that there was intention to create legal relation in that particular situation, or there wasn't? The promise by the father to pay her 500 Ghana cedis for all her hard work in relation to, if you like, the writing of the demand notice. Was there intention to create legal relation? Was there intention to create legal relation?
Hello, Doug.
Yes.
Yes, I would say yes. Because that arrangement is made in a commercial setting. Asking somebody to write demand notice is a commercial transaction. So unless we have the honorable clause made by the owner of the business, that's the father, even though this is a kind of domestic arrangement, this is a domestic arrangement, but it has that commercial element attached. So I'll base my argument on Hammer versus Hammer and Innocent.
Hammer and Innocent.
Yes.
What happened?
Oh, this was one of the agreements between a parent and a son, but was done in a commercial setting. So the court says that unless there is that express statement of the father, the agreement will not be binding. It should bind.
All right. Okay. Did you say Hammer and Innocent?
Yes, please.
Okay. All right. Now I'm happy that you were not misled by the mere fact that it is a father and a daughter to just come to conclusion that all the two contractual scenarios between the father and the daughter should be treated as domestic and social agreement. No. So as the last contributor rightly demonstrated, if you examine the story, we do not have anything for us to conclude that the request by the father Amoako to the daughter Boatemaa to write the demand notice to the debtors of the business could not have been treated as a commercial agreement. There's nothing to show. And for that matter, to all intents and purposes, if you look at the activity and the transaction involved, you could see that this was a commercial work, so to speak. And for that matter, there's nothing wrong if you wanted to argue that there was intention to create a legal relation, despite the fact that the parties were, because don't forget that when we say commercial agreement, it does not mean that between a father and a child or between parents and children, there can never be commercial agreement. There can be. So it's a question of the circumstances. It's not just the family relationship. So let's keep that in mind. Okay, so I think that is very good. Our friend who flagged breach of contract as issue, will you outline the principles for us if you want us to discuss it? I hope you are around. You've not left.
Doc, please, I'm around.
Yeah, so summarize the principles on breach of contract for us.
Doc, please, breach of contract can be said to be where a party to a contract refuses to perform or does not perform his part of the contract. That is how I would explain breach of contract. So from what we have said so far, we can say that
so before you do the analysis, you've not finished with the statement of the law. You haven't cited any authority. And let me say to all of us that, please, anytime you are dealing with the question in the common law type of subject, contract, tort, contract, tort especially, if you don't cite authorities, your examiners will really be unhappy with you, okay? Because the principles are located in the authorities. If you are not citing the authorities, what it means is that where did you get your principles from? Yeah, so my good friend, give us at least one authority on what you have said. In other words, like one case law which supports all the things that you have said. And breach of contract, there are a lot of them, isn't it? Are you there? Hello?
Please, I'm around.
Yes.
Doc, please, I'm around.
Okay.
Doc, this one I would need help from someone.
Oh no, the breach of contract. Most of the cases in relation to terms of contract are illustrative of breach of contract. Most of the cases in relation to remedies for breach of contract.
Pusat versus Spider.
Pusat and Spears.
Yes.
Pusat and Spears. Okay. Of course, because if you go there, there's an issue about breach, isn't it?
Bettini versus J.
Bettini and J, yes. All those things are illustrative. If you like. So as for that one, there are a lot of cases. And even in Hong Kong Fair, they're all, because you have to know that there's a relationship between terms of contract and discharge of contract by breach. It should not be looked at in isolation. It's just because of how we teach, according to topic by topic. That is why students get the impression that they are in different, waters, but they are in the same stream, actually. Good. And my friend, when we were stating the principle about the breach of contract, you should have also stated that breach of contract, which will really bring about termination of the contract, has to be, what do you call, the repudiatory breach. That is, it should relate to breach of a major term, as in a condition, and so on. But as you look at these facts, you notice that you don't have enough information for you to build discussion on the breach of contract. Of course, everything can be, you can treat everything as a question of breach of contract. But in terms of it being very much an issue, like being, at the center stage of discussion in terms of what the parties are actually, controverting about, I think that we don't have much. But if you raise it and you stated the principle correctly and you give the authorities and you made effort to apply them, nobody will mark you wrong. Yeah, so that is fine. I'm told that my battery is running low, so anytime my laptop will go off. And for that matter, I'm going to end the class. I was going to move to the last bit, the conclusion. The conclusion, that is, we are asked to advise Amoako. We haven't advised him yet, so let us keep that in mind. We haven't advised Amoako yet. So we need to ask ourselves, Amoako want to know whether he's obliged to do so. Is he obliged to honor the various promises? The promise to pay the 1,000 Ghana cedis if Boatemaa did not smoke, the promise to pay 500 Ghana cedis for writing demand notice and all those things. Ulu said that Amoako must honor those promises. Otherwise, if he's taken to court, he is going to be found liable for breach of contract and be made to pay damages and so on. So that is what we are supposed to do in the conclusion. Okay. Okay, so we will end that here, and I've given you the clue as to how to arrive at the conclusion. So we'll continue again tomorrow. Have a very good night.
Good night, Doc.
Thank you, Doc.